case briefs, and so much more. LSData's got what you're looking for.
In 1999, the Supreme Court of the United States heard the case of Alden v. Maine, which centered around the notion that states cannot be sued in their own courts without giving permission first. The lawsuit was initiated by a group of probation officers who accused their employer, the state of Maine, of violating the overtime provisions of the Fair Labor Standards Act of 1938. After the Seminole Tribe of FLA v. Florida case, it was established that Congress lacked the power to override a state's sovereign immunity from lawsuits in federal courts. Consequently, the district court dismissed the officers' claim, which was later affirmed by the Court of Appeals. The probation officers then filed the same lawsuit in state court, but it was dismissed by the state trial court and upheld by the Maine Supreme Judicial Court. The Supreme Court ultimately held that Congress does not have the authority to compel non-consenting states to face private lawsuits for damages in state courts. In this case, Maine had not given its consent to lawsuits for overtime pay and liquidated damages under the Fair Labor Standards Act. The court upheld the decision of the Maine Supreme Judicial Court, emphasizing that states had given consent to lawsuits brought forth by the United States, but not by individual employees. The ruling clarified that Maine had not waived its sovereign immunity, permitting it to choose which lawsuits to consent to. This decision struck a balance between federal law and state sovereignty by establishing rules that corrected ongoing legal violations and upheld the Supremacy Clause.
Case briefs, and so much more. LSData's got what you're looking for. Visit lsd.law, elevate your mind. Leave the stress of class.